I rise to speak in favour of Amendment 1 in the name of the member for North West Hampshire, who's definitely on the other side of the House, but who I'm very much allied with in seeing the clear flaws in this bill. Like the Honourable Member, I remain uncomfortable about this bill as a whole, which I'm sure will come as no surprise to the Minister. I was quite clear in my concerns during the bill's second reading, concerns that unfortunately the Minister failed to adequately respond to. Under this bill, someone who successfully appeals against an order taking their British citizenship away would not get their citizenship back until it's no longer possible for the government to challenge that appeal. At present, this amount of time is indefinite, making this a measure which is effectively designed to circumvent the judiciary, and I want to understand fully why. Now, during this bill's second reading, I repeatedly asked the Minister to specify what act a person must commit to fall into the particularly unique situation where the government would want to revoke their citizenship, and why there is no existing legislation that can be used to take criminal proceedings against or imprison them as someone who is extremely dangerous. And I would really like the Minister to give a clear example beyond the one case that has sparked this knee-jerk response of where this legislation would be required, because he has to recognise that once law, it can be used in more than one way and in more than one case, as the Honourable Member opposite has quite clearly laid out. And also because if the answer is no, if this bill's only being brought about to address this one specific example and yet potentially has implications for dual nationals or for those with eligibility for citizenship elsewhere, then surely the Minister can understand the apprehension that many will have about this particular legislation. Now, I mentioned during the second reading debate that certain communities are often wary of legislation that touches on citizenship because it almost always, whether it is the stated intention or not, disproportionately impacts them. And to put this clearly to the Minister, I'm talking about people of Black, Asian and minority ethnic communities, those who have parents who may have been born elsewhere, or grandparents for that matter. They will be particularly alarmed by this legislation. Those of us who have entitlement to citizenship from other countries for no other reason than where our parents may have been born or where our grandparents may have been born, or simply because of our ethnic origin, will know that we are at higher risk of having our British citizenship revoked. And when such legislation is passed, it creates two tiers of citizenship. It creates second-class citizens. And we have known that quite clearly since the Shamima Begum case. Now, this, as far as I'm concerned, goes beyond keeping people safe and beyond a technical adjustment. It sends a message that certain people in certain communities are forever second-class citizens, that no matter how long you contributed to this country, your citizenship is conditional, it's revocable and it is disposable. It seems we've learnt nothing from the Windrush scandal at all, because we continue to go in this cycle of creating pieces of legislation that may impact certain communities, noticing that it may impact those communities and passing them anyway. The power to remove someone's citizenship has its roots, as far as I'm concerned, in colonial logic, where belonging is granted or revoked at the whim of empire. But there is no more empire. That logic has no place in a modern democratic society. Citizenship should never be a privilege to be granted or withdrawn based on the political agenda of the day. Citizenship is and should be a right. It is the foundation of equality before the law, and even though this may not be intended to do this, this bill undermines the right for some while safeguarding it for others. Now, I'm against this bill, not just because of what it does, but because of what it says. And so I would like to ask why the Minister has not seen it fit to conduct an equality impact assessment on this bill. I know it is an incredibly narrow scope, but its potential implications are vast and the potential impact limited to specific communities. Steps should really have been taken to understand the impact that this legislation might have. Now, I want to take some time to actually speak to Amendment 1, which I do hope the government will consider. And we know that these cases are lengthy and can last several years. And again, I point to the Shamima Begum case as an example of that. Now, to leave somebody essentially stateless as the government exhausts the appeals process risks their freedom and their safety. While the government may wish to wash their hands with the individual to whom they are seeking to deprive of citizenship, as is evidenced by the very nature of appeal, that person and their safety be, is and absolutely ought to be by law the responsibility of their government. If rendering them stateless throughout the appeal, whether it lasts a few months or a few years, risks harm to the individual, then it's only right that a judge can rule that the order does not continue to take effect until the appeals process is exhausted. Ultimately, I believe this legislation to be reactionary, but also born out of frustration of failures of existing legislation. If someone is deemed to have such a severe threat to public safety and existing legislation does not allow the government to deal with the matter appropriately, then we must amend the existing legislation. Now, as I said before, I'm against this bill not just because of what it does, but also because of what it says, and what it says about who we are, and what it says about whose rights matter, and about whether justice in this country is truly blind, or whether it sees skin colour and migration history before it sees the individual and before it sees the citizen. I genuinely do not believe that this knee-jerk approach is the answer, and creating second-class citizens is the answer. There surely has to be another way. Does he agree with me that it's not even an exact science, this whole notion of heritage? For example, my first black ancestor to be born in this country was born in 1806 in Twyford. I have no idea where it is, but I know it's not that far from here. And he was the son of a formerly enslaved person and of a white domestic servant living in the house of his former master. Now, I don't know what that particular ancestry is, but that goes quite far back. Someone called Birch, who was living in the UK, who would be deemed British by this law. Now, just because he travelled, this Thomas Birch Freeman, as a missionary to Ghana and settled there, and this is where my lineage has now come from, I am now treated differently under the law, despite perhaps having heritage that may be similar to the Honourable Gentleman's. Just to further the Honourable Member's intervention, would the Honourable Member be aware that Commonwealth countries in particular allow people to claim citizenship from the birth of their parents or their grandparents, but not just that. There are some countries, notably Ghana and Kenya, who are specifically allowing people to claim citizenship purely being of African heritage, and for the reason that they may not be able to trace their lineage due to enslavement. He's made very clear exactly where this will apply, but will he be clear about exactly who it will apply to? We've asked this question perhaps in different ways, talking about who we think will be disadvantaged, but can he be clear that those who are of British nationality, who have no other claim to nationality, could not be subject to this order? I just wanted to ask the Minister if he might publish the assessment, and also to go further and say he continuously says that it is fair, but I want to impress upon him that it cannot possibly be fair that should this order be brought about, that it would impact me and not him, should it happen. I don't think that's fair at all. And I also would like the Minister to address the fact that it's not discriminatory just because he says it's not. He has to understand that because some communities may have this applied against them more than others, even though it's used sparingly, that fact makes it discriminatory. And he has to accept that. I would be very grateful if he would address those points. I'd also be grateful if he would quite specifically think about the fact that no matter how sparingly this legislation is applied, that it is being used more than it has been in the past, and that causes people, much cause for concern. But not just that. That, as the Honourable Member opposite actually pointed to, he himself, the Minister and the Secretary of State may not always be in this place, and there may be others that may wish to use it in a way that is not intended. I would be very grateful if the Minister could address these points and see exactly where our concerns remain. Thank you.